Just before the break, we took the opportunity to apply our knowledge of the requirements for preparing a plat of survey in order to see if the example plat would stand up to the standards. Now let's look at what is required documentation on a plat of survey. First, it shall be drawn on a dimensionally stable media and contain the following information: the direction and length of each line expressed in degrees, minutes, and seconds, and to the hundredth of a foot. Curved lines should be identified with a point of beginning and ending, along with enough curved data to define the curve. Any prominent terrain features the boundary may follow should be described. The area should be provided and be calculated to the nearest 100th of an acre. Monuments are to be noted as either being found or set, along with a description of the monument, including the length, diameter, material, and any identifying information. Trees used as monuments should be called out by species, diameter, method of marking, and whether a record monument or newly established. Reference at least one corner of the property to at least one of the following: a corner of the parent tract, a durable and recognizable physical object, or a properly identified primary control network. The name and record source of roads should be shown on a plat of survey, keeping in mind that sometimes the record source is difficult to find. If an assumption is made on the right-of-way width, make note of that on the plat of survey. If the center line of the road is used and the adjoining property runs to the center line of the road, then the neighbor across the street may be a property adjoiner, in which case we would need to pay attention to the next required item to be shown on the plat of survey: the names and record sources of the adjoining properties, as well as the name and record source of adjoining subdivisions. Any apparent encroachments discovered during the survey should be shown. The reference meridian is to be noted as the basis of bearings. For example, true north, grid north with datum information, record north with a citation to the source, or magnetic north with a date and location of the observation. A vicinity map is required to be on the plat of survey unless the location of the parcel is clearly shown on the plat. The error of closure or relative positional accuracy should be noted, along with a statement indicating whether the distances shown are based on an adjusted or unadjusted traverse. The survey classification is to be noted. Any cemetery or grave sites evident from either the field work or required research should be shown. The plat of survey should be signed and sealed by the supervising professional land surveyor. Both a written and a graphic scale are to be placed on the plat of survey. A plat of survey must also have a title block containing the name and address of the client, the name and address of the property owner of record, a title for the survey, A statement of compliance with 201 KAR 18150 and the name and address of the professional surveyor who performed the survey, including the surveying firm if applicable. The parcels surveyed must also be noted on the face of the plat with the record source and location or address of the tracts surveyed. Section 11 of 201 KAR 18150 notes that a plat of survey must be signed, sealed, and dated. It is also noted that working drawings or unfinished plats are to be marked in at least 16-point type, which is approximately 1/4 of an inch, with the following language, quote, preliminary, not for recording or land transfer, end quote. Partial boundary surveys. This is an item that during the in-person courses can sometimes generate discussion. Some people are in favor of this potential and other people are deeply against the use of partial boundary surveys. In either case, we're going to look at the requirements as stated in KAR 18150. Section 12 addresses partial boundary surveys in two different situations. The first situation is in creation of a smaller tract of land, and Section 12 states that the need to survey an entire parent tract in order to create a smaller tract is not required if 1. There is adequate evidence conforming to the record deed, and 2. Enough verifiable monumentation exists to establish both the subject and adjoining common lines. The second case being addressed for partial boundary surveys is when a survey is conducted in order to mark a boundary line or replace a boundary corner. So Section 12 states, in performing a boundary survey, it is not necessary to survey the entire boundary in order to mark a boundary line or replace a boundary corner if 1. Sufficient evidence supports the portion of the boundary being surveyed, and 2. The work done does not adversely affect adjoining properties. In each of these cases, one must rely upon their professional judgment to be able to determine that adequate evidence exists, it's verifiable, and there is no conflict with adjoining property rights. In either case, a plat of survey of that portion surveyed will be required to meet the standards in the rest of 201 KAR 18150. A 2011 addition to 201 KAR 18150 provides specific standards to follow when preparing non-boundary drawings. Sometimes it is useful to plot a deed in order to have a meaningful discussion with the client, or you may prepare survey drawings depicting existing conditions without relating them to the boundary. In these cases, the drawing must state on the face of it the intended use of the representation, and in at least 12-point or just under 1/4 of an inch type, have a statement made that the work does not represent a boundary survey and is not intended for land transfer. These drawings may be signed and sealed by the professional in responsible charge. In addition to the intent and disclosure of not being a boundary survey, It is also necessary to state on these drawings who the product was created for, what the purpose of the product is, how the product was created, where the parcel is located, when the work was performed and any certification date, the scale of the product, and the degree of accuracy which the work product represents. As a final section of legislation, we will very briefly discuss 201 KAR 18200, which outlines the minimum standards of practice for mortgage inspections in Kentucky. In discussion during the in-person course, many people have expressed the opinion that they do not think mortgage inspections should be allowed to be performed. They discuss situations of haphazard work being passed off as meeting the standards we will be discussing on the following slides. I have personally done one that I can recall in about 20 years of practice. The reason I choose not to do them is that aside from setting corner monuments, if one diligently follows the standards for a mortgage inspection, you have essentially performed a boundary survey. There are actually portions of these standards for a mortgage inspection that are in excess of what is required to perform a boundary survey per KAR 18150, specifically addressing the contract between the buyer and the surveyor. The following requirements are in place when conducting a mortgage inspection in Kentucky. First, adequate research of both the subject and adjoining deeds is required. Adequate is left somewhat open to professional interpretation. However, if we think back to a boundary survey and the record requirements for it, we needed to search for relevant documents of record, relevant public agency records, and other available pertinent data, with relevant and pertinent being a professional interpretation. So this has a similarity to the boundary survey requirements. One item that is required and often overlooked in performing a mortgage inspection in Kentucky is that a work order is required to be in place. The work order must state that the borrower, not the mortgage company that called and made the request, but the borrower, has been advised of the types of surveys available and the scope of each one of them. And this work order must be signed by the borrower. There are many required items that must be included in the work order from parties involved to delivery date. One required statement is a very lengthy description of the various types of survey services that the borrower has acknowledged that they understand. This includes a mortgage inspection versus a boundary survey versus an ALTA ACSM land title survey. It is required in a mortgage inspection to make a diligent search for monumentation. So in the instances when I have heard complaints, a lot of the complaints are around the subject area of the drive-by inspection, where a fence row or a mow line is used as evidence of the line. In those cases, it is apparent that a diligent search for monumentation has not occurred. The word diligent is open to some interpretation, but again, we need to think in terms of what would the standards of professional practice be in our area. It is also required to show improvements as noted in the KAR during the inspection. These should be dimensioned in such a manner as to be sufficient to locate on the property. This is only one of many required items to be shown on the drawing. However, one item that cannot appear on the drawing is the word survey in any certification. Showing improvements is required in a mortgage inspection, but nothing in the standards for a boundary survey require the showing of improvements. Another item that is required to be on a mortgage inspection is that you must prominently place the statement, quote, mortgage inspection. This does not constitute a boundary survey and is not a recordable document on the face of the drawing. I generally put that statement in red so that it is very visible if I were to perform more of these. Mortgage inspections are required to be signed, sealed, and dated. As we wrap up this course, we'll take a few minutes to look at data supplied to the CAPS Board of Directors from the Kentucky Board of Licensure for Professional Engineers and Land Surveyors. As was noted earlier on in the presentation, the Board of Licensure is not out to get people. We reviewed the many roles they are to perform. They do protect the public by guiding the professions of engineering and land surveying through the development and enforcement of regulations, a task which was assigned by the legislature. The board members and staff are very helpful in trying to clarify any concerns that professional licensees may have about statutes and regulations. In addition, they have been proactive in trying to make sure licensees are aware of recurrent issues so that the licensee can be sure to not fail to address those potential issues. Having provided a top 5 common standards violations list in the past, the board staff have recently provided the following updated top 4 standards violations, which we will review. The first deficiency in the top 4 deficiencies is actually a recurrence from the previous top 5 that was made available several years ago. That is the source and title for roadways. I'll read this quote directly from the Board of Licensure staff, which states that the source of title for roadways, we understand that many Kentucky roads do not have a source of title, as in a deed to the county or state. When that is the case, the landowner across the county or state road becomes the adjoining property owner, and their name and source of title should be shown and their deed analyzed in comparison to the subject property deed. End quote. The source of this requirement is 201 KAR 18150, Section 4, Item J, and Section 5, Items G and H. The name and record source of subject and adjoiner properties, the name and record source of each road. Note that from the Board of Licensure staff, there's clearly the intent to analyze the subject and adjoining deeds because they understand that the center line of the road may or may not be the property line and that the boundary may run to one side or the other of said road. So we have to take care and make sure that we don't just call out a roadway as the adjoiner when it may not be the actual adjoiner. The next common deficiency is, quote, name and address of the surveyor's client in addition to the name and address of the property owner. Many times they will be the same, but not always. The surveyor's client could be a potential buyer, a realtor, an attorney, or other person who does not currently own the property. If the client and landowner are the same, simply list owner/client, John Doe, 123 North 4th Street, etc. End quote. The source for this requirement is 201 KAR 18-150, Section 5, Item S, which requires the name and address of both the client and the owner. The third common deficiency that we'll look at is, quote, "We've seen more addresses left off of the surveyed property recently. I'm not sure why. Some of the most recent surveys we've looked at have been very rural, in already rural areas. If a property has no known address, it would be acceptable to list its PVA tax parcel ID number. That will at least make it locatable on a tax map." End quote. The source for this requirement is 201 KAR 18-150, Section 10, Item 5, Subitem T, Part 2, the location or address of each parcel surveyed. The final common deficiency we'll look at is, quote, "Trees. The standards require certain conditions when a surveyor may use a tree as a monument." Section 9. That section also requires the surveyor to mark the tree in a conspicuous manner. Section 10(5)(c) requires the surveyor to provide a notation as to whether each monument was found or set. In the context of a tree monument, set may not be the appropriate term. The surveyor should note whether the tree corner is a record monument, found, or newly established, set monument. End quote. They've cited the passages of KAR that apply, but I'm going to recap them quickly. So the sources of these requirements: 201 KAR 18-150, Section 9, Item 7, deals with trees as monuments. 201 KAR 18-150, Section 10(5)(c) requires the notation of a monument as being found or set. In addition, I would note that Section 201 KAR 18-150, Section 10, Item 4, Subitem F, requires the notation in a written description as to whether a tree is of record or established during this survey. (2016 to 2018) Complaints addressed by the Kentucky Board of Licensure for professional engineers and land surveyors. From information provided by the Board of Licensure, we will have a brief look at the volume of and types of complaints that are submitted, investigated, and resolved. These actions are regularly seen in the respective publications of the Kentucky Association of Professional Surveyors and the Kentucky Society of Professional Engineers. If you are a reader of the Interior Angle or Kentucky Engineer, you have probably seen the Board of Licensure reports and may already know the most common violation. In the 2016 to 2018 time period being reported on, 113 complaints were opened pertaining to professional engineer licensees or firms. 72 complaints were opened pertaining to professional land surveyor licensees or firms, for a total of 185 complaints opened over the 3 years reported. Of those 185 cases, only 60 resulted in disciplinary action after investigation. During investigation, additional violations came to light, so there were a total of 79 violations over the 3-year reporting period. The Board of Licensure report indicates that, in many cases, it is determined that no violation occurred or disciplinary action is not required. For example, in minor violations, a letter of admonishment or warning may be issued, and these are not classified as a disciplinary action. In looking at the types of violations that were discovered from the investigation of complaints, we see that the most common issue is either not having or not renewing a permit. Over 1/4 of all violations are covered by this issue. As we discussed earlier in the course, the firm permit has an annual renewal date, while the license is renewed every 2 years. The individual or company is ultimately responsible for making sure that they renew in a timely manner. Continuing professional development issues are the next largest slice of the pie, accounting for just under 1/4 of the violations. This section covers both failure to obtain the required hours and failure to respond to an audit of your hours. The CPD requirements have been in place for a number of years. It should be well known by each licensee that they are required to obtain a certain number of hours per reporting period. However, there are several people who do not do so. As we discussed earlier in the course, when you renew your license, you must confirm that you are in compliance with the required hours. It would be unethical to report that you are complying when you are not. In addition, late renewal will automatically trigger an audit of your CPD hours. Another 16% of the violations pertain to failure to comply with the standards of practice as we covered in 201 KAR 18150. Failing to meet the terms of a settlement agreement made with the Board of Licensure accounts for an additional 10% of the violations, with the unlicensed practice of engineering or land surveying rounding out the double-digit percent violations. An additional 5% of the violations are the result of the reciprocal action we discussed earlier in the course, wherein a disciplinary action against a license held in another state may result in the same disciplinary action occurring within Kentucky. Criminal convictions resulted in 3% of the violations discovered in the reporting period. Recall from earlier in the course that a felony conviction involving violence, sexual misconduct, fraud, or deceit makes an individual ineligible for licensure. We're in the home stretch now. The final section of the course will involve a quick look at some of the sections of 201 KAR 18 that we have not yet addressed. In 201 KAR 18-080, it is noted that a licensee is required to conspicuously display his or her license in his or her place of business if doing business with the public, either individually or as the CEO or a consultant. It is also necessary to display your license conspicuously if teaching a design course in an engineering or land surveying program accredited by ABET. We mentioned the Surveying Core Curriculum when we reviewed the sections of KRS 322 that applied to the process of becoming licensed. This core curriculum is set forth in 201 KAR 18092. Note that the required hours have many options for specific content one could study within surveying. This outline leaves open the potential for taking all non-boundary surveying coursework. This concerns me because I would wonder how the Board of Licensure could turn down an applicant based on meeting this requirement as stated. I think there is the potential for the wording of this curriculum to become problematic if pressed. This may be a potential issue to address in future revisions of the regulations. Continuing professional development is addressed in 201 KAR 18192 for professional land surveyors and 196 for professional engineers. Since much of the language is the same, we will look at both sections within this one slide. For those who may not be aware of the intricacies of professional development courses, a course provider can either seek to have content be pre-approved by the Continuing Professional Development Committee or not seek that pre-approval. If a course has been pre-approved, then it will meet the standards set forth in this section. If a course has not been pre-approved, it still may meet those requirements, but has simply not been submitted for review. If a course which has not been pre-approved is questioned as to if it meets the requirements, the pertinent information may be submitted after the fact for review. If the course is not accepted, a licensee will have 180 days to gain the needed hours. Guidelines for submitting a course or activity for pre-approval are provided within this section. CPD hours may be gained from a long list of possible methods, which include taking a course at a university or college, taking seminars or correspondence courses, and additional activities may also count. As long as the activities are relevant to professional practice, contain technical, ethical, or managerial subjects, are an organized program of learning, are conducted by individuals with education, training, or expertise, are offered for the hours recommended by the author of the course, subject to the Continuing Professional Development Committee review, but cannot include in-service training, orientation to institutional policies, or time to sell or advertise products. CPD hours must be reported during the online renewal process, as we have previously discussed. Audits of CPD hours can occur for various reasons. As we earlier discussed, failure to renew your license in a timely manner results in an automatic audit of hours. However, there is also a random selection process which results in you having the potential to have your CPD hours audited. If audited within 30 days of the request, you simply provide the board with proof of completion of the hours within the audit period. When you read the disciplinary actions from the Board of Licensure reports that are in the CAPS and KSPE publications we spoke about earlier, they are the result of a formal process for administrative hearings as outlined in 201 KAR 18-220. An oversimplification of the process can be thought of as: a complaint is made, an investigation is conducted, a decision concerning the complaint is reached. However, with several potential outcomes at various steps along the way, the process is more complicated than these three steps. From this flowchart, we can see that beginning at the investigation and moving forward, there are additional potential outcomes that vary based upon the results of the investigation, the seriousness of the violation, and decisions of both the board and the licensee being investigated. This flowchart is still a simplified version of the potential paths. There are many intermediate potentials that impact the final result of a disciplinary action. Following the path of a violation having been found, we see at least three potential outcomes. A minor violation may result in a letter of admonishment, and that may be all that is required. If a more serious violation is found, a consent decree will be negotiated between the executive director and the licensee. This consent decree will be presented to the board for approval. If the board rejects the consent decree, an administrative complaint may be filed. More serious infractions can result in an administrative hearing that will be carried out per Kentucky Revised Statutes, Chapter 13B. An administrative complaint will result in a hearing. If the respondent defaults on the hearing, it is taken as an admission of the allegations against the licensee. The administrative hearing will result in a consent decree which will be entered as the final order. In reading the disciplinary actions, it is not too unusual to see that a licensee has faced more severe disciplinary action due to a failure to comply with either a consent decree or a final order. As the last step to this seminar, please follow the link on the last slide of this presentation and complete the review of this course. Constructive feedback can be helpful in future revisions to the course. In addition, please make liberal use of the area for suggesting future seminar topics. If you are aware of an individual who would be particularly engaging for the topic, please also leave a suggested name so that we can try to reach out to that individual. Thank you for taking this online course. While it is a time-consuming process to develop and provide an online learning opportunity, CAPS is willing to investigate trying to create additional content available through the online classroom as a convenience to professionals trying to gain continuing professional development. If you have ideas that you would like to see presented, please let us know.